all of the appeals for their own determination. We've got no indication as yet as to whether that's likely to happen. So that was a brief introduction from me. Before moving on to agenda item 2 and asking those attending to introduce themselves, could I ask that those not likely to speak switch their cameras off, just to assist us in chairing the meeting? So we have a list of parties that we're expecting to be participating today, and I'll run through those parties and ask you to identify yourselves in turn, starting with those representing SEPA.
Yes. Good morning, sir. My name is James Finlay, King's Counsel. I believe on the call today we have Paul Adams, Nina Robertson, Ian Boyd and Lucy Hennessy from Thornton's, and from SEPA itself, Jeremy Warner and Susan Watson.
Thanks for that, Mr. Finlay. And now I'm just going to run through a list of appellants, starting with Cook Aquaculture Scotland Limited.
Yes, sir. My name's Karen Hamilton. I'm a partner with Brodie's Solicitors, and I'm representing Cook at today's meeting. Also present at the meeting this morning is Ben Johnson from Cook. Ben is Head of Environment.
Great, thanks for that. And those representing Organic Sea Harvest Limited.
That's myself, Laura Tainch. I'm partner at Davison Chalmers Stewart. I'm representing them today, and they aren't on the call directly today.
Okay, thanks very much for that. And those representing Baccafrost Scotland Limited.
Hi there, my name's Joanna Waddle. I'm a lawyer at CMS, and we're representing Baccafrost today, who are not on the call. My colleague Mark McMurray is also on the call from CMS.
Thanks for that. And those representing Loch Long Salmon Limited.
Good morning, sir. My name's Ewan McLeod. I'm a solicitor with Shepherd and Wedderburn, and I'll be representing. I'll be representing. I'm sorry, an IT issue here.
Thanks, I got that, Mr. McLeod. And those representing Kames Fish Farming.
Sorry, sir. I'm also representing Kames this morning, sir. And for completeness, I'll mention that I'm representing one of the third parties, Salmon Scotland, which is the industry body for the salmon industry. And we've been playing something of a coordinating role in relation to the appellants and their position.
Great, thanks for that. And those representing Loch Duart PLC.
Good morning, sir. My name is Ashley McCann, solicitor at Shepherd and Wedderburn, and I'm instructed by Naomi Dempsey and Hazel Wade of Loch Duart, who are also on the call today.
Great, thanks for that. And those representing Maui Scotland Limited.
Sir, I'm also representing Maui Scotland Limited today. And present from the company, we have on the call Stephen McIntyre, Head of Environment, and Douglas Hunter, I believe, Technical Director.
Thanks for that. We're getting there. Those representing Scottish Sea Farms Limited.
Good morning, sir. My name's Craig Welton, solicitor with Shepherd and Wedderburn, and I'm representing Scottish Sea Farms.
Lovely, thank you. And the final appellant I have is Don Fresh Farming Limited. Is that you, Ms. Hamilton?
Yes, sir. We are also representing Don Fresh.
Perfect, thank you. The interested parties then, Mr. McLeod has indicated that he's representing Salmon Scotland. Mr. Linley Adams representing Wildfish, are you present?
Yes, I am.
Perfect, thanks for that. And Dr. Jaffa? No, Dr. Jaffa. Yep. And finally, Miss Feenan for Fisheries Management Scotland. Are you present?
Yes, I'm here. Thank you.
Thanks for that. Okay, so I'll now hand over to Mr. Seaton to lead discussion on agenda item 3 onwards.
Right. I think, actually, item 3 is really simply about statutory procedure under which these appeals are to be handled. There was a question raised in SEPA's submission that matters could be dealt with by written submissions. I think it's acknowledged now that it is a matter of law that a hearing is required in these. So I'm not sure if any further discussion is required on that agenda item. Moving on to agenda item 4, the procedural issues to be considered. Now, there is the first issue, as prompted by the appellants, is SEPA has produced a response, an initial response to the written response to the appeals, but it hasn't produced a completed response. And I think we're looking for a time within which SEPA is going to provide its completed written response. What's a realistic time? It's both a completed response, I suppose, to the appeals, including what SEPA refers to as grounds 8 and 10, which are respectively the new reporting requirements imposed by the conditions of its revised licenses and the human rights issue. And second, because SEPA's list of cases doesn't cover all the cases, all the appeals that have been made so far. Just to confirm that SEPA's response or further response will cover all those cases. Mr. Finlay.
Yep. Yes, my understanding is that the outstanding items need to do with the competition point and the human rights point. And I'm instructed that a response in respect to those and outline response in respect to those will be available within 6 weeks of today. And I haven't had express instructions, but unless I'm told otherwise during the course of this meeting, I understand our preliminary response will cover all the appeals and we'll make that clear. I should indicate at this stage that given that Loch Long Salmon are present, that whilst I'm representing SEPA in terms of the procedural hearings, I won't be representing SEPA against Loch Long Salmon in respect of any merits hearings. But that may cause complications in the future, but it won't, hopefully today or in the short term. I represented Loch Long Salmon in an appeal that's decision still outstanding for.
Yes, noted. Okay. So if we're talking 6 weeks from now, that's so we're talking 13th or Wednesday, 13th of August. Is everyone content that any of the appellants want to respond? Everyone content that SEPA should a deadline should be set for 13th of August, Mr. MacLeod?
Just one or two observations on what Mr. Finlay had to say there. So Mr. Finlay referred to an outline response in relation to the competition and ECHR aspects. And to be clear, I think what the appellants are likely to be looking for is a full and final response on SEPA's position on those matters and any other matters in the appeal. Because as you'll be aware, sir, the response to the appeals on behalf of SEPA did contain fairly general reservation as to other things that it might want to say in response to the appeals. And the appellant's position, as I understand it, is they want to understand the case that SEPA puts against them. And that is important because it may influence the legal questions that you need to ask. It may influence or will influence the responses that the appellants make SEPA's position. And I don't think anyone would take any issue with mid-August as being the date by which SEPA should respond, but that should be a full response in relation to all matters outstanding in the appeals.
Mr. I see your hand up.
So, Mr. McMurray.
Mr. McMurray, I'm sorry, Mr. McMurray.
Yes, sorry. Good morning, sir. I just wanted to flag just by my calculation, I think 6 weeks would take us to the 20th of August, but I could probably my.
Is that right? Okay. Well, I'll take that correction to the 20th of August, right? Okay, Mr. Finlay, why should SEPA not produce a full and final response to the appeals in writing by 20th of August?
Yeah. What we were asked for was an outline response. That's what we provided so far. It's full and final in the sense, it's certainly final in the sense it's set on the matters we dealt with, sets out our position. It's not appropriate at all to have a full and final statement of our complete case and evidence against parties at this stage. In our submission, what SEPA have done has perhaps gone beyond providing a purely outlined statement in respect to the matters that they have responded. They've provided a fairly full response. In planning terms, it might be considered to be equivalent of a statement of case. And usually both parties provide a statement of case at the same time. SEPA provided a very full statement of case. So I'm not suggesting we're going to provide anything different in terms of the outstanding items that we provided in terms of a general approach that we provided already. But I do suggest that and do resist any suggestion that we should be providing our whole case in the sense of all the material upon which we're going to refer to and the like. In our submission, given what was asked of us, we will continue to provide an outline statement in response to the two outstanding grounds. And if there are, we will review the other aspects, and if there are other matters that have been left open, we will reconsider those. But we have sought to give a full outline response in respect of all other grounds. Certainly, my understanding, I wasn't involved in the preparation of that response, but my understanding is that was what was intended, save for the two that I've indicated. So this is a I don't know whether there's actually a dispute between myself and Mr. McLeod on that basis, but I do strenuously resist going further than providing what you might expect in terms of, for instance, the equivalent statement of case at this stage.
Mr. McLeod, you wanted to respond?
Thank you, sir. This point was flagged in the potential timetable that was circulated a couple of weeks ago, where we set out what we thought might be procedural steps that would be helpful for you and any other reporters appointed in the appeals. And we highlighted a part of SEPA's response document, which basically says that although SEPA had attempted to respond to the points in the appeals as comprehensively as possible, they were not in a position to respond at that point in time fully. So that was 30th of May, I think. And that it was prejudicial to ask them to do otherwise at that point in time. They said that SEPA reserve the right to make further submissions as might be necessary, and that where no comment was made on a particular ground of appeal or paragraph, it shouldn't be taken as an indication that SEPA accepted the ground of appeal or statement set out there. Now, I accept what Mr. Finlay says about what SEPA was asked to provide at that point in time, but we're now 5 or 6 weeks beyond that. We're talking about further 6 weeks beyond today's date, i.e. 3 months in total since SEPA set out its outline position. The appellants still don't know what SEPA's full case is. I don't know whether SEPA knows what its full case is, and it might be useful to understand that. Is it the case that SEPA is still working out what its case is? Or is it the case that SEPA knows what its case is, but is not willing to disclose it to us and to you? Either way, the appellants are prejudiced because they don't know what SEPA is going to say. And that may have a bearing, as I said, on the questions that you want to ask as preliminary matters on the legal side of things. And it may ultimately have a bearing on the nature of any evidential hearing if that is necessary at some point in the future.
There's a question of fair notice, isn't it?
It is, sir, yes.
So can I respond to that? I mean, Mr. McLeod is referring to paragraph 1.5 of our SEPA's response, which is entirely appropriate. As I say, Mr. McLeod may enjoy poking fun, but SEPA knows what its case is. It's set it out in full. In my apologies, an outline. It's, for instance, it's contemplating that if there was an evidential hearing, it would call 6 witnesses, which will speak to matters in much greater detail. To ask for SEPA's full case at this stage is wholly inconsistent with any form of procedure on any appeal of which I'm aware. And to ask SEPA to do it prior to disclosing, for the appellants disclosing even an outline of their case is extraordinary. The appellants, with respect, are not suffering prejudice. If this matter goes to appeal, there will be a perfectly fair procedure for disclosure of each side's case, usually a mutual disclosure at the appropriate time. SEPA, as I've submitted so far, have provided a fairly full outline of their case, save on the 2 points which I've indicated, which require specialist legal input, which will, due to holidays and matters, we've asked for 6 weeks to deal with. But SEPA is quite entitled to put the general caveat they have done in 1.5, as you would expect in any document at this stage. I do resist the idea that there should be full and final disclosure of SEPA's case at this stage.
So in terms of further procedure, SEPA would rely on this document as giving fair notice to parties if evidential hearings are held, or if a debate is held on the matters that are listed there, with the exception of items 8 and 10. Is that right?
Yeah. My understanding. Well, it's not. We haven't been formally asked for a statement of case yet, so my understanding is that it is in respect of matters 8 and 10, it provides SEPA the outline of SEPA's response on the grounds of appeal. Yes, so that should provide at this stage fair notice of the points that SEPA wishes to take in outline. Sometimes in a fair bit of detail, but in general terms, yes. But if these appeals are to proceed and there is a formal request for a statement of case or an outline statement of case, and it may well be that SEPA in due course will ask to see what the appellant's statement of case is, then no doubt that will be provided for.
Well, I mean, as you know, Mr. Finlay, that this isn't an inquiry procedure, so there aren't, there aren't the kind of formal statement of case and then recognitions of witnesses and so on. The normal procedure is simply that there are responses to, there's an appeal which gives notice of the party case. There are responses to the appeal, and then usually that is the basis for a hearing. So I'm not sure. And you seem to be adding some steps to the process.
Well, I think so. In this case, there are, leaving aside the legal points, there are distinct, there are clearly significant evidential disputes as to which have been raised in pretty well every appeal. Some of them vary one from the other. There's going to have to be some form of procedure to identify the basis of those evidential disputes and for an exchange of evidence to deal with them, would be my submission. It cannot be that the parties are going to turn up at a hearing without any prior indication either of the particular issues that they wish to raise, or the evidence upon which they're going to rely. If it's the case that all the appellants are prepared to confirm that all the points they wish to raise are raised in their grounds of appeal, then we could perhaps dispose of a statement, the equivalent of a statement of case. I'm fully aware it's not a planning inquiry, although but the procedure, as I understand it, that is to be adopted will be very much for whichever reporters are eventually appointed. None being appointed yet so far. This is in normal appeals under these regulations, the issues will be much more straightforward, and the simple grounds of appeal and response may well then lead to a hearing with all parties fully appraised of what's going to be raised. In this, I'd be surprised if the appellants wish to stand or be taken not to go outside their grounds of appeal at this stage. If they are, so be it. They clearly wish to know what SEPA's response is outline responses in terms of the two remaining grounds, and I've indicated we have a timetable to deal with that. But perhaps I've jumped ahead in the sense that, but I should have made the point earlier that this is a case which is going to involve significant evidence from a number of expert witnesses. So far, SEPA's identified at least 6 which it would wish to call, 2 of which are likely to be from different jurisdictions. And why I'm objecting to a full and final part of our case is that to try and summarize their evidence as opposed to the headline points of the case we're putting forward at this stage would be disproportionate. We need to have that evidence in place. It's not the case of making our case up, as Mr. McLeod puts it. It's providing the evidence in a fit and state to deal with the points that have been raised in the appeal. And that will be a matter that will be dealt with in due course, should the appeals go ahead, if any preliminary points of law are determined one way or the other.
Do you want to comment?
Briefly, sir, thank you. These appeals and the procedure that we're discussing today do have to be seen in context. These are appeals against SEPA-initiated variations. We're not in a situation where, to borrow from planning appeal terminology, we're looking at a deemed refusal appeal where the planning authority perhaps feels that it's been caught on the hop, doesn't fully understand the appellant's case, hasn't had the opportunity to consider the matter. On SEPA's evidence, they've been considering this issue for years. And to suggest today that in 6 weeks' time they will not be able to set out their full position in response to the appellant's reactive response to the variations that SEPA proactively put forward is very difficult to accept. It's also particularly difficult to accept when we look at the terms of the SEPA response to appeals in paragraph 17.2, which makes a plea for no hearings, written submissions only, and concludes that the grounds of appeal and supporting information submitted by the appellants are extensive. Are extensive, and it's not anticipated that additional matters will need to be raised at a hearing stage. So at that point in time, and there is a potential inconsistency in what SEPA was saying in 17.2 and what it says elsewhere. On the face of it, 17.2 may be saying SEPA's case is more or less what's set out in this document, subject to the specific reservations on competition law and human rights. But then 1.5 says you can't take it as read that just because we haven't commented on a particular ground of appeal, we accept it. And that's the difficulty that the appellants have. They need to understand what SEPA's position is. Today's the first day that we heard that there would be potentially 6 witnesses on behalf of SEPA. We don't know what they're going to cover. The fact that some of them are from other jurisdictions is, well, it's a matter for SEPA who they lead. But for example, we don't know, or the appellants don't know, whether SEPA intends to lead any site-specific evidence beyond what they have today. We don't know whether SEPA, or what SEPA has to say in full on the issue of whether it's competent to impose an activity through a variation to an and these are all matters which we don't want to get into. The question of whether activities, is there a distinction between an activity and an operation, which is one of the issues that the appellants raise. I'm not sure that we fully understand SEPA's position on that. And what I was going to say just towards the end of that there was we don't need to resolve these issues today, and it's obviously not appropriate to get into the fine detail of it, but there does need to come a point in time where SEPA sets out its full position. I understand that there may be hearings in due course where witnesses are called to speak to that final position, but the final position must be final, because only then will you and the other reporters know what issues you're actually grappling with.
I mean, I'm not sure. Are we not talking about? Obviously, SEPA is not necessarily going to put forward in its appeal response every word of the evidence in it. Well, perhaps not. Perhaps that's not obvious. That SEPA is going to put forward every word of the evidence in that its witnesses might give at the hearing, or that might be in some kind of document prepared for a hearing on a specific topic. But I suppose what you're looking for is fair notice of its position on every topic. That's what you're looking for, Mr. MacLeod, yeah. And is that the sound?
That's not disputed.
Right.
That's why Mr. MacLeod continues to talk about full notice, and then talks, his example was knowing what exactly our legal submissions are going to be on activity and operation. I'm not sufficiently familiar with our response document to deal with that particular point, but I can understand that he should know what our headline position is on that, whether we feel that there is a distinction and whether it's competent to, which I believe we have made it clear that it is competent to include both activities and operations. I don't consider it necessary at this stage for SEPA to set out its full legal submissions in support of that. That would be a matter that comes later. Likewise, the point you made about evidence, or indeed the specific identity of witnesses, which Mr. MacLeod seems to make issue of. Those are all matters that would not be in an outline response. As I've said already some minutes ago, my understanding is that SEPA has given fair notice of the points that it will take in response to the grounds of appeal, save on grounds 8 and 10.
To maybe to roll this up, if I suggest that SEPA's response on 20th of August should be expected to give fair notice of its response on every point.
More than
at least an outline. I think we will come on to discussing the actual further procedures that we're going to take. So perhaps we can decide in respect of that whether SEPA needs to identify witnesses in an outline response on 20th of August, or whether they can be identified for particular further procedure that we hold. Is that satisfactory? Well, Mr. MacLeod, Mr. Finley's indicated that's satisfactory, I think. And other appellants too, obviously.
I was going to make that point, sir, because although I'm trying to act as a mouthpiece for the appellants, they may have their own position.
I understand.
I mean, I think if I maybe set out my position for Salmon Scotland and for the two appellants I am representing today, I think that if there's a requirement for SEPA to provide a submission on all points and to give fair notice by a date in August, that seems like a reasonable approach. I think we can all reserve our positions in due course as to whether fair notice was given on that date in terms of what SEPA submits. But if the instruction to SEPA is to provide fair notice by a point in August, that seems like a fair approach. So.
Okay. And Sam.
Yes, thank you, sir. I would echo what Mr. MacLeod just said in relation to reserving our position on what comes in, and sounds like a reasonable approach. The point which I wish to make was that the SEPA response to date has very much, I think, touched on common points between or amongst the various appellants, and there are certainly a number of points made by individual appellants which have not been addressed. I think that probably applies across the board, and so I think it was to raise a marker that I think the SEPA response will need to go further in terms of diving into the individual nature of the appeals in order to give fair notice on all points.
Were you thinking particularly of points that apply to particular farms, or points that apply generally that one party is that might apply generally, but that only one party has raised, or both?
I think it's probably a case of both, sir.
Okay. Right. And Mr. Finley, I take it you don't have. If it's a question that SEPA's response is not complete, not only in respect of grounds 8 and 10, but in respect of other matters that have been raised by particular parties that simply haven't been addressed by SEPA, can we expect that SEPA will produce a response to all of those points too?
Well, so if you're going to call for that, then the answer would be yes, but given the sheer number of appeals, we would need longer than 6 weeks to do so. And so I'd be suggesting a 2-tier response to your fair notice I do wish to resile from the headline, the fact that we will give if you like, our response on human rights and competition within 6 weeks. The one of the issues I was going to raise in due course was whether it would be appropriate to identify test appeals. And I've had some discussion with Mr. McLeod as to this, so that whilst there are.
Okay, can we come on to that kind of that kind of arrangement subsequently, or unless it relates to particularly to this particular point?
It does, because if a specific response is wanted on all however many 200 plus appeals, down to a particular level of detail, then that will be significant amount of work for SEPA, which it will undoubtedly do. But that's why I raised the issue of test appeals at this stage. Is that entirely appropriate and proportionate? If, say, leaving aside the legal issues which apply to every matter, say 6, and I'm just using that for sake of argument, say 6 test appeals are chosen to proceed, it would in SEPA's submission be far more proportionate that at that stage that it then it would give the full detail of its response to those 6 or however many test appeals there may be. Otherwise, there's going to be a full response to provide a full response to the 200 plus appeals on what's an appropriate level of detail. I would need to take instructions as to the time that will take.
Well, just I go through a process in which a test appeal was dealt with. I'm not immensely attracted to the process of using test appeals, because obviously what happens is that a decision is given, and the parties who might be disappointed with that decision will find reasons in the other appeals to address that. It's an awful lot. I'm not attracted to the prospect of test appeals. If we have to go down that line, and if other people are thinking that's a good way to go, then we'll certainly look to it. But it wasn't a terribly easy process in other contexts, I have to say. As regards to other mechanisms of addressing points in all the appeals, there is a degree of similarity in all the submissions. Maybe people are going to address that. I see 3 hands raised. Possibly there could be a process of the appellants identifying points that haven't been addressed in SEPA's submission. Perhaps that gets too complicated. Anyway, having said that, I'll maybe take people who have raised their hands. So Ms. Tange first, and then Mr. Hamilton, and then Mr. McLeod.
Sorry, I expect the others might have similar points, but we have discussed amongst the appellants that perhaps test cases would be appropriate. My point was going to be that I think the number suggested of 4 or 5 wouldn't be appropriate, because it would be better to have every appellant have at least one, because they are common. There are many common points, but all of the operators will have some distinct points. So the only appropriate way of dealing with that would be to allow each of the appellants to have at least one test case.
I can say I wouldn't, certainly 6 was simply a point of judgment, but if 1 per appellant or more if necessary, it's just a question of slimming down from 200 plus to a manageable number.
Right. So Charles and then Mr. McLeod, and then we'll come back to Mr. Finlay.
Thank you, sir. I wasn't going to address the matter of test cases. I thought perhaps that was a matter best addressed at the next stage in procedure. However, coming back to the point about fair notice being given on points which haven't been addressed at all at the moment, I think it's not so extensive an exercise as Mr. Finlay may be suggesting. Certainly for our part, a statement of appeal was lodged which related to all our cases, but drew out individual strands where there was a particular divergence or where a particular characteristic arose in relation to one site or one appellant, and that was done in a single document. I think it's also worth making the point that the appellants have had to do this exercise in a fairly limited period of time in responding to the appeals, and so it doesn't seem unreasonable to ask that SEPA should have to do a similar exercise in responding to those statements of appeal, and it can be done in a similarly efficient manner as the appellants have adopted.
Obviously, there's six how many groups of lawyers representing the appellants, or with a smaller number of cases, the SEPA's got to deal with them all. So I got that impression that there was a fair degree of consistency between the various appeals. And would it be appropriate for the appellants before the date for SEPA's response to flag up the points that they consider SEPA hasn't addressed? Would that assist in getting a full response from SEPA? Perhaps I should ask Mr. MacLeod to come in before I go back to Mr. Finlay. Right.
Thanks, sir. I was putting my hand up for Mr. Welton, who's got something to say.
Oh, right. I'm sorry.
We're sharing screen and microphone this morning, sir. Thank you. It is in large part reiterating what Ms. Hamilton has said about the procedure and test cases. I think we need to understand, because at this point we don't know what SEPA's position is in terms of site specifics. They haven't provided any real site specific evidence, and I think it would be helpful in the 6-week document, if I can call it that, if SEPA could at least set out what its site-specific evidence would look like in terms of each site. I think that's a distinction from having to provide that evidence in respect of every site that they've chosen to serve a notice on. And that would help the appellants. I think certainly my instructions at the moment are not to support a test case approach, in part because we simply don't know what his position is on the site specifics. I think we need to know that first. And I think that is something that presumably could be provided within the 6 weeks. And then, as I think Ms. Hamilton was suggesting, we could then look at further procedure from there. And simply just in fairness to our clients, and you're quite right, there's a lot of lawyers on here. But I think the context of the burden on SEPA needs to be seen, that in the case of my clients, they received 37 notices, some 6 weeks after having already submitted appeals on the first tranche of notices. So SEPA was fully aware at the time it chose to serve those further 37 notices of the grounds of appeal that they would be facing. And the fact that my clients have had to lodge 74 appeals to which SEPA is now having to respond is, I'm afraid, entirely of SEPA's own making. If they don't want to submit evidence to support notices they've served, it's always open to them to withdraw those notices.
So just going back to your initial point, Mr. Welton, you were suggesting that you would want to know in SEPA's 20th of August statement what the shape of its evidence on individual sites would be. Is that a fair summary of what you said?
Absolutely, sir. Yes.
Okay, Mr. Finlay.
Well, we would certainly be assisted if appellants were able to point out where they felt that SEPA had not responded to site-specific matters or other matters. And if my current instructions are that if the 6-week timetable is extended to 8 weeks, we would hopefully be in a position to be able to respond and give fair notice in terms of the response to site-specific matters too. Obviously, the level of evidence and detail on site specifics will be we will have to consider, but I quite understand the need to give fair notice in response to points. The level at which that can be given will need to be analysed further. But the two-stage process that you suggest, either the 8-week period starting from whenever your note comes out, but preferably from after the outstanding issues are identified, would be of assistance to us.
Right. So, sorry, I'm sorry, you're saying 8 weeks from the point at which the appellants notify SEPA of the outstanding issues?
Yeah. Well, yes, my understanding is that in terms of the overall issues, SEPA has identified the headline or combined issues. It's my understanding, I may be wrong, that it's more the site-specific issues that it is suggested that SEPA has not responded to. So, in order to assist SEPA in ensuring that it doesn't miss any of those site-specific issues, it would certainly be helpful to have that two-stage process. I'm instructed that it would to ask for 8 weeks from when that notice is given of identifying those site-specific points. But SEPA will be working on that in the meantime, and has indeed been already. It's not a process that would be started, has not yet started. It has, but that's what I would seek in response in respect of that.
Well, how do the appellants feel about that? About a process in which they make submissions on points that SEPA require to address, and then there's a period within which SEPA is to respond to that. SEPA's already started its response. It says so. Perhaps, well, SEPA's asking for 8 weeks, but perhaps 8 weeks before 8 weeks is not necessary. Perhaps you could set an earlier deadline in view of how much more is needed. We could decide how whether a later deadline can be allowed.
Perhaps I could suggest that if parties were to notify SEPA within 2 weeks of whenever your note comes out, or today, whichever the start point is taken to be, and then SEPA would endeavour to respond 6 weeks thereafter.
Right.
It would be 8 weeks in total. But I think the point that we're really anxious is that we have sufficient time after we've received parties' identification of points we haven't dealt with in order to respond to them, and we have a large number to go through. But can I suggest that, subject to the caveat, if for holidays or other reasons that proves to be difficult, we may come back. But that's the timetable at the moment I would suggest to give parties a target to come back on.
Okay. How do parties feel about that? How do the appellants feel about that? I'm looking to anyone to respond. Is everyone nodding? No one's actually actively disagreeing, right? Okay, so we can do that then.
And I think that can be 2 weeks from today, and then 6 weeks. Needn't wait for the note to be issued.
Right. So the next point is about dealing with issues common to the appeals. I think actually we can probably take B and C on the agenda together. So I think it is agreed between parties, and certainly no one's demurred that there are common issues and that they could be dealt with or potentially be dealt with in a preliminary hearing. Is everyone happy with that? And that in particular, certain legal issues can be dealt with. Is everyone happy with that? Yeah. Okay, no one's disagreeing. Okay, so the question is how that would happen. Yes, at this point it might be worth looking at the annex to the notice, and I've done a kind of initial draft of issues that might be discussed in a hearing and preliminary hearing, and on what presumptions they might be discussed. I got an email last night from Thornton's on behalf of SEPA suggesting that only issues 1, 2, and 3 should be discussed in a preliminary hearing. Those are whether the operation of Green Penfish Farms is licensable activity, whether that licensable activity can be added as a new controlled activity under a variation of the existing license under Regulation 22, and third, the procedural matters, including the assessment that requires to be carried out under Regulation 15.1, whether those should have been carried out. So those 3 matters, it's SEPA suggesting that a preliminary hearing should be limited to that. Does anyone, I have to say I have some sympathy for SEPA's view, but does anyone have any thoughts on that?
Can I add one point just to that? That I had preliminary discussions with Mr. McLeod this morning, and certainly issues 7A and 8A
yes,
are on reflection more closed than I'd originally analysed them to be, and I can see that they could well be preliminary issues as well, because they don't rely on evidence, because 7B and 8B are the much broader questions that would then follow. But so 7A, and I certainly, unless instructed otherwise, my current view is that 7A and 8A, subject to appropriate assumptions, particularly in respect to 7A, would be suitable. It may be helpful to put that out before others respond.
Good. I mean, that was actually going to be my suggestion too. But so does anyone else want to respond on the legal issue with McLeod?
Just briefly to say that aspects of 6, again, I think the appellant's broad. Can you hear me okay?
Yes, can you? Yeah.
I think broadly speaking, the appellants that I've spoken to understand SEPA's position in relation to the need for evidence on some of these, but there may be others where there are legal aspects that could be dealt with in terms of preliminary ruling. So 6 on competition law, 9 to an extent on human rights.
Yeah.
Albeit that there may be preliminary questions to be asked, but we don't know what those are yet, because we don't know what SEPA's position on those is. And I think others may have points in relation to 4 and the question of evidence in general. But I might hand over to others to cover that point.
Right. Hold on.
If anybody's
Let me remind myself of 4 before we talk about it.
4 is to do with whether SEPA's evidence in support of the sea lice regulatory framework is sufficient to establish that the operation is likely to have significant adverse impact on the water environment.
Mm-hmm.
And again, I suppose there is an aspect of maybe not knowing what SEPA's full case is here, SEPA has told us to date what it relies on. I think Mr. Welton made the point about, is there actually any site-specific evidence beyond that that SEPA intends to rely on? I don't think we know that at this point in time. But I see Ms. McCann's got her hand up as well.
Right, yeah. Yeah, Ms. McCann, do you want to come in?
Yes, thank you, sir. It was on the framing of issue 4. I wondered if SEPA's concern around that issue could be addressed by reframing it to focus on the question of whether site-specific evidence is needed in principle, rather than the question of whether the evidence underpinning the sea lice framework is sufficient. So I think that is quite an important matter
Right.
to draw out before we get on to any evidential hearings on site specifics to follow.
Ms. Finlay, do you want to comment on that point? Or should I just check if the other appellants have any other points? Well, nobody else is raising their hand, so do you want to come back on that, Mr. Finlay?
Well, yes, there's a certain allurement in the suggestion made, but some sites, it may be, not all sites will be the same. Some sites, so SEPA may take the view there's no need for site-specific evidence, particular site-specific evidence. Some sites there may be. I maintain SEPA's response that you received last night in respect to that. It will be a matter of evidence in respect to each site rather than and until you are aware of the evidence that SEPA is calling for you to make a ruling that you need to provide site-specific evidence as opposed to the evidence that SEPA calls would be a decision taken in a vacuum in this respect. So I would oppose that.
Right. Just say. So, okay. Well, I think it's Hamilton and then Mr. McLeod.
Thank you, sir. And you'd be perhaps coming on to this, but I think our position generally in relation to the annex and the issues, particularly given the setting out of the assumptions, we would welcome a further period of time to digest these. I think it's obviously going to be certainly a critical issue in terms of the scope of any preliminary hearing and the assumptions to be made related to the eventual items that are identified. And yes, without prejudging where you were about to go next, I think certainly we would welcome the opportunity to have further time and indeed further discussion. And it may be that a measure of agreement could be reached through further discussion with SEPA as well on that, and we could come back to you, sir, on those matters.
Mr. Clyde.
It's just a point in response to something that Mr. Finlay said. So I have him noted as saying that SEPA may take the view that some sites may need site-specific evidence and some may not. That in a way illustrates part of the difficulty that the appellants have. We don't know which sites those are. We don't know what that evidence is, whether it exists, in what form. We're in the dark, or the appellants are in the dark. And if SEPA's position is, as Mr. Finlay described it, that is a critical factor that needs to be explained in the 6-week document, and specific sites do need to be identified so the appellants can consider how they respond to whatever it is SEPA is going to say.
Well, Mr. Finlay, do you want to respond to that, and I'll come back to it. Okay.
Our reject the suggestion that the appellants are as in the dark as Mr. MacLeod suggests. But the way from SEPA's evidence that has been outlined so far, or case that has been probably more appropriately, but has been outlined so far in its response to it is clear that SEPA takes the view that all the relevant fish farms need some form of control based on the risks that they have identified. My understanding of SEPA's position is that those risks are inherent with the operation of the activity. Again, to use my wording more carefully, are inherent in either the activity or operation, depending on how one describes it, in any event, so that there may not need to be specific, for instance, risks identified with specific fish farms, but there may be. In terms of the 8-week document that I proposed, certainly that is a matter that SEPA can give consideration to as to whether it will, and if so, which individual fish farms it will provide site-specific evidence on. But I would caveat that it will have to keep that matter under review, depending upon material that is subsequently provided by the individual appellants. Because if individual appellants wish to put forward site-specific material, it may well be that SEPA will then need to respond to it, even though they didn't consider that that was appropriate to present their initial case.
Sorry, I'm not sure I entirely followed you, Mr. Finlay. I'm meant to understand that SEPA will address what evidence it is required, and I think you've undertaken to address the evidence required.
Yeah, I just the latter point was just a caveat that it will put forward its position as it understands it at the end of whatever period you and the chief reporter determine, but it's a caveat as to that position, that that position may change in the light of material that appellants bring forward, but that's probably likely to be the case in any.
Yeah. And on the other point raised by Mr. Hamilton about question of yes, by agreement of the further agreement of legal issues. I mean, obviously everyone's only seen the more up-to-date version of this yesterday. Is SEPA in a position to agree or to refine these issues further and come back to us with a better final list? Is that something that the appellants and SEPA would do?
I'm very happy that SEPA works with other parties to refine the list. If we're not to deal with it today, then Ms. Hamilton's suggestion is entirely sensible, and further thought can no doubt be given to the particular wording of the assumptions, on the understanding that the assumptions are only assumptions for the specific purpose of determining the legal issues, and won't be binding parties on either side going forward. So yes, in short answer, yes, that seems to be a sensible suggestion to try and refine those by way of further agreement. And it would appear that we are broadly, potentially apart from issue 4, and potentially in part from Mr. MacLeod's concerns about the as yet unanswered issues, broadly there's some broad level of agreement. So refinement should be quite possible.
Yeah, just we'll come back to that. But Mr. McMurray, you had your hand up and you've taken down again. Is your point addressed, or is it? Did you want to raise something?
No, I was just I was going to follow up on Ms Hamilton's point around the the need for the clarity and on the questions and working on that. And my point was just going to be that I think our clients certainly will probably, from initial discussions we've had with them, find it difficult to refine these questions until we've seen the full SEPA response. So it feels like the time we're doing that and discussing with SEPA to refine these questions possibly once we've had that response down the line.
Okay, right, that's noted. Okay. So, but in broad terms, everyone is content that the hearing on, or potentially to the terms of the review, which we yet to discuss, the people are generally content that the preliminary hearing could be held on issues 1, 2, and 3, and 7A and 8A, or people aren't at this point finding an objection to those at least, and that. Well, no doubt the assumptions will need to be worked on which those will be discussed, and as you say, they wouldn't be binding on parties in subsequent evidence. The question that Ms McCann raised about item 4, the question of the evidence and individual evidence for whether individual evidence is required, is something that perhaps can be discussed between SEPA and the appellants. But broadly, I think there's if you can leave it at that for the moment, on that there can be, well, that in principle a preliminary hearing is a good idea. Now, we've been going for an hour and 10 minutes. I think I'm in need of a couple of copies. Does anyone feel that we could take a 10-minute break and then we can come back to discuss the terms of how we might have a preliminary hearing? Is everyone content to have a break just now? We're desperate to press on. No? Okay, right. So we'll have a break and come back at 20 past. From return now. Where's there? Mr. McLeod and Mr. Pelton have better light. That's good.
We've relocated so we don't look like witnesses in some sort of witness protection program, or we do.
Yes. Okay. I think everyone else is back, are they? Is Mr. Teach back? Wait, she is. Right, good. Okay, well, we'll press on. So we've looked at the basis on which a debate might, what a preliminary debate on legal issues might deal with, and we've discussed assumptions which can be refined. I suppose the questions are then about the procedure for the preliminary. So if we had such a debate, would we just hold it as a roundtable discussion with all the appellants and SEPA and potential third parties, or should we're going to come on to the involvement of third parties, but should we hold it as a roundtable discussion, or are there some other rules of engagement that we should have? We're going to. Does anyone have a view on that? I mean, the kind of default position would be to have a roundtable discussion. Everyone content with that?
I think from the appellant side, I believe the appellants are content with that. We'll come on to item 7 in the agenda in due course as to what needs to happen in advance of that. But I think the suggestion of a roundtable discussion is definitely workable from everyone's perspective on the appellant side.
So it's really primarily a matter for you, how you, assuming that there will be the equivalent of legal submissions set out in advance, how you would then prefer those to be spoken to, whether it's by you identifying particular issues, allowing parties to make submissions with an agenda in advance, or whether you would like parties to a more formal, if you like, akin to a court type situation where parties made submissions, others responded, and there may be a reply. But it seems to me that that's primarily a position for you, or a matter for you, as to what would assist you most in dealing with matters that are going to be legal submissions.
Well, and I guess that's something we can consider, and we're quite far out from it at the moment, so we'll consider that further and maybe comment in our notes on any view. But I take it from the discussion that a roundtable discussion is applicable to everyone, if that how we decide to play it. It would certainly give everyone notice if we took a different view and let them comment. The other question I had was, obviously, presumably, well, I think our view would be to, if we were persuaded on the legal issues that the licenses simply couldn't be amended in the way that SEPA has proposed, we would issue a decision to that effect. And I guess that would be the end of the cases that affected, assuming all of them, if it affected all of them. If we took the view that the cases could proceed to evidence, I think again we could issue a preliminary legal ruling on the points in the preliminary discussion. Is everyone content that we can do that? Are there limits on what we can make a ruling on? Mr. McLeod?
I was going to raise just one point in relation to Schedule 9 of the regulations. And paragraph 18 says that after the conclusion of a hearing, the appointed person must make a report to the Scottish ministers in writing, which must include the conclusions and recommendations of that person, or the reasons for not making any recommendation. and that was my question yesterday about the nature of your appointment or any reporter's appointment was linked to that, because it struck me that one way of dealing with that, if one way of dealing with that would be that at the end of the hearing on legal issues, you simply adjourn the hearing with the possibility of reopening it for evidence. So you're not actually concluding the hearing at that stage. And I think that would allow you to make a procedural ruling if that was necessary. Equally, I agree with you that if you took the view at the end of the legal hearing that some of the preliminary issues were fatal to the notices, as the appellants say they are, then you could decide the case at that point, subject to the terms of your appointment and whether you're deciding or reporting.
Right. Okay. So everybody's content with that, are they? Okay. Good. So I think we can. The next point on the agenda was about it's not appropriate for the preliminary hearing. So I think that we can skip over that if everyone's content to do that. That's point E. Point F is about third parties and the way that third parties should be incorporated in proceedings. We've got a number of third parties here. So Ms. Lindley added or anyone else. Obviously, Salmon Scotland is one of the third parties as well. I imagine Salmon Scotland would want to be represented in the hearing, Mr. McLeod. And Ms. Lindley Adams, Wildfish, have indicated that they would like to make some written submissions only. Yeah.
Yes, if I may, it's very clear you have an awful lot on your plate, and therefore we'd be very happy to limit our involvement to written submissions in response to any of the various toing froings between the main two parties. But I would perhaps, if I may, just encourage you to keep everyone on a very tight rein, simply because of the notices of variation won't come into effect until these proceedings are concluded, and all the while the fish, if you like, that I represent, the wild fish, are waiting for these changes to the car licenses to come into effect to help them. So if I may ask you to keep everyone on a tight rein and not let the timetable slip too far, that would be my submission. Thank you.
Okay. Right, well, we'll come on to written submissions and we can maybe consider how Wildfish would take part in that. Fisheries Management Scotland is here too, and I don't know if Mr. Martin Jaffa is around.
Dr. Jaffa is present.
Oh, he is, right. Okay. Are either of you Wildfish, or does or Dr. Jaffa? Do you consider would you want to take part in the hearing?
Hello, yes. I'm not sure I would take part directly in the hearing, but I certainly would be interested in making submissions. I mean, my contention is that the whole science behind the SEPA strategy is flawed and needs much further examination. But that's obviously for further discussion.
Mm-hmm. We'll come on to the written submissions following on from SEPA's Commissioner SEPA's submission and have dates for that. But at least in terms of preliminary hearing, you're not considering on your own behalf taking part in that.
So,
okay, and Fisheries Management Scotland, are you here?
Yeah, and same for me. I'm not interested in participating in the preliminary hearing. Thank you.
Okay, good. Right. Right. Okay, so that takes us on to the last point here. Is it? I've crossed over with point 7. I'm afraid that my agenda does rather cross over a couple of points. Well, perhaps we should take timetable. I don't know if we can decide dates and locations and duration just now, but perhaps we can discuss that. Perhaps the better way of discussing is just to discuss the further timetable for written submissions, which kind of goes back to where we were near the beginning of this discussion. So we have SEPA's response. Well, we have the parties 2 weeks from now, the parties, the appellants giving notice of the points that they consider SEPA hasn't addressed. Then so that's 2 weeks, and then 6 weeks. After that, SEPA is to make a submission giving fair notice of its case. I imagine the appellants will want to at least update the submissions they have made after that. So the appellants have already responded in writing to SEPA's initial submission. So I assume that it's maybe not necessary to revise those submissions entirely, but I imagine the appellants will want to produce a written submission after that. How long do the appellants need? Well, if we said 4 weeks after SEPA's submission to respond to it or complete responses to it, I guess if there's any difficulty with that, you can come back at that time if there's any issue that you need longer to respond to. Is that fair? Right. So 4 weeks after that. Okay. Right. I don't think anyone's demurring from that. Okay. In terms of preliminary hearing, I think Mr. McLeod has referred to his helpful timetable, which suggested that we as reporters or the reporter appointed might want to ask specific further questions. I think we just don't know at this stage if we would want to ask specific further questions before a preliminary hearing. So I would suggest that we just leave that until we reach that point, and that we just set a preliminary date for a hearing, maybe, I don't know, 4 or 6 weeks after the appellant's responses. So we can pencil that in, and if for any reason the timetable slips, well, we'll just have to arrange something else, but at least we'll have something in the diary. It's obviously quite a lot of people with quite a lot of diaries, so it's probably a good idea to have a date set. So everyone content with that? So if we said, I don't know, 4 weeks after the appellant's responses for the hearing,
which I think might be the 2nd of October.
Which would be 2nd of October. There's so much calculating. I would try to toss it up. Right, 2nd of October. I'll just take a moment to think about that. Or are you Mr. Hyde's indicating he's fine with it. Sounds and Mrs. Dainch are not demurring.
Sorry, I was actually my thumbs up service to indicate I'd like to take just a moment to consider.
All right, you're right.
Apologies.
What do we just take a 5-minute break if you want to talk about it, or well, Mr. Hamilton, we'll take Mr. Hamilton and Mr. McMurray first, and then Mr. Hamilton.
Sir, in terms of your reference to a refined set of questions from the reporter, I had understood that that reference was a reference to the agreed items that we would be addressing at the legal debate, and it's whether parties would address those in writing in advance of the debate or not, rather than, I think, there may be further points. I had understood that that was what was intended.
Yeah, so there would need to be a bit of time for those to be refined, wouldn't there? Once SEPA's statement is out, and once the appellant statement is the appellant's report response to SEPA are complete, may need to be a bit of time for the appellant and SEPA to discuss those issues and agree a final list of issues for debate. Is that fair?
So I think that was perhaps Mr. McMurdy's point from earlier, but certainly I think that would be useful if following the first exchange between the parties, then there is it's at that point that we reach a final landing on those items.
Right. Okay. So, Mr. McNamara, was that your point?
It was going to be, as much as I admire the positivity and optimism, sorry, I felt that 4 weeks was perhaps overly ambitious if we had to refine and agree on the questions plus have submissions prior to any hearing, but that was, say, just my initial thoughts on the matter.
Okay, right. So do you think well, if we said 2 weeks after the appellant's responses to agree the terms of the debate, and then 4 weeks after that for the debate itself, for the preliminary hearing itself, does that make sense? And I mean, obviously, if issues come up that need longer, we might just have to adjust the timetable. But as penciling things in, does that make sense to everyone? Mr. McCann.
I'm content with that time period for a hearing in principle, sir, but I should flag that the beginning of the week commencing 10th of November, which I think is where we land, is difficult for our clients from an availability point of view. So it would be subject to specific dates being appropriate.
Right. Okay. Well, I mean, we can always have a rough estimate and ask people to check their diaries. No doubt people don't have their diaries, everyone doesn't have their diaries for November, so we can identify dates subsequent to this to pencil in for the final meeting, the preliminary meeting.
So I think that would be sensible if we could, once we've got your note, parties could, through the case officer, try and identify a suitable date so that everyone can have a review of their diaries. But certainly, the beginning of November is getting quite busy for me as well.
Yeah. Okay. Sorry, and I talked about questions that we as reporters might have. I suppose we would consider whether we have any specific further questions. But as you say, the agreed terms would be agreed issues for the debate for the preliminary hearing would largely be framed between parties. I think you're right. So Mr. MacLeod has a hand up first, then Ms. McCann. Mr. MacLeod?
Thank you, sir. It was just going back to the draft timetable that we'd set out.
Mm-hmm.
There were 2 steps that we had suggested in between the finalisation of questions and the hearing, and those were first both sides, if you like, providing responses to your questions, and then each side being given an opportunity to comment on the other side's comments. And the thinking there was that by the time that you get to finalising your set of questions, all of the evidence, or maybe not all the evidence, but all of the key information necessary to answer those questions should be available. The parties may not have actually answered your questions specifically at that point. And our thinking was that if we were to answer them in advance in writing, that would perhaps cut down the load for you when it came to the discussion on the day. Now, as Mr. Finlay said earlier, the procedure is really a matter for you, but we thought that it might be useful for both sides to set out their actual responses to the questions you want answered in writing.
Yeah, of course, that makes sense. Yeah. So let's have a think. So so if we had weeks after the submission of the sorry, Ms. McCann, did you had a question too?
Thank you, sir. Mr. MacLeod covered that point. It was
Right. So I suppose, yes, that's right. There would be in 4 weeks after the appellants would provide their response, there would be 2 weeks for hopefully 2 weeks for the appellants and SEPA to agree on any findings they want us to make to the questions that we're asking at the preliminary hearing. We have to, I guess, we have to issue those questions, so that may take another week or so. And then we'd ask you to respond to them in writing. And I suppose we would have an exchange of responses. So each party would respond to the question maybe in 2 weeks and then respond to each other 2 weeks after that. So we've got 4 weeks. 12. We're talking 23 weeks from now for a preliminary hearing. Does that follow the same arithmetic? So just to go through it, there's parties, appellants to provide their outstanding points to SEPA, 6 further weeks for SEPA to respond to that, 4 weeks for parties to respond to SEPA, or appellants to respond to SEPA. Is that right? Oh no, I've got it wrong. 3 weeks for parties to comment on the terms of further questions that should be put in the preliminary debate, and for us to issue the questions for the preliminary debate. 2 weeks for appellants and SEPA to respond to, or for all parties to respond in writing to the questions for debate in the preliminary hearing, and 2 weeks for them to reply to each other, which gives us 2, 6, 12, 15, 19 weeks, I'm sorry, yeah. Is there any content for that? Yeah. Okay. So
That takes us to a week beginning the 17th of November.
17th of November. Is that still problematic for your clients, Ms. McCann? No. Okay.
Oh, thank you.
So that week I'm engaged in a wind farm inquiry.
Right.
Let me just. The following week, apart from the Tuesday, is and the Friday, I am free.
How long do people think? I mean, I suppose it depends on how many issues we're discussing, but I mean, my guess would be a day would be sufficient to cover all matters, or is that being optimistic again?
Well, with the amount of procedure and exchanges built into the procedure, I'd have thought a day was realistic.
Right. Okay. So if we penciled in, say, Wednesday, 26th of November for the hearing, subject to all of those exchanges, as we can.
I just wonder, sir, whether we need to reserve our position on that, given parties are still exploring the option of joint instruction of counsel.
So we could. Yeah, no, you're quite right. But I said we would reserve our position. You're quite right. Okay. So we've got a rough timetable, and parties potentially in that week, starting the 24th of November, we can decide on final dates. Yeah. Okay. Right. What else do we have to do? I have mentioned the location of a preliminary hearing. If there's capacity at DPA offices, does anyone have any? If it's to be in person or virtual, I would suggest in person at the DPA offices. Is that acceptable to everyone if we have that? Yep. Ms. McLeod?
I think in person is probably the preference from the appellants. The only thing that I would say is that given the number of appellants and interested parties. I don't know whether DPA's offices will be quite big enough.
Okay.
I haven't been there for a hearing myself, but somebody who was recently commented that it can accommodate a number of people, clearly, but I think we might be looking at needing a slightly bigger venue, unfortunately.
Right.
We can sit, roughly speaking, 30 people around a hearing table. Are you thinking there are likely to be more than that?
And we could webcast it as well, I suppose.
Yeah. No, I wasn't thinking more than that. I hadn't appreciated that you could accommodate that number, so that may well be fine in that case.
Maybe what's happened, we can dismantle walls and make the conference room bigger or smaller. So maybe someone has been in a foreshortened room.
So we've dealt with timetable for submissions up to the preliminary hearing. I don't know if we can take it any further than that into evidential hearings. It's probably not a good idea to go further than that. Is everyone content with that? That we don't yet set a timetable for further submissions on evidence? Yeah. Okay. Right. We will issue a note of this meeting, which we would expect people, if people want to comment on it, we would be quite happy to receive comments. Later. Is there anything I've missed that we still need to discuss? Take a moment to think about it. Nobody's raising their hands. Okay. Right. Well, that's good. So we'll get on with drafting a note of the meeting, and thanks to everyone for attending. So yeah, very, very useful. Okay.
Thank you very much.
Thanks all.
Thank you.
Thank you.
Thank you.
Thank you.